This is so common among law students and lecturers. When we say rule of law, mention rule of law, we always remember Albert when some people say Daichi, some people say Daisy. Now it consists of three main elements: supremacy of the law, equality before the law, and referring to unwritten British Constitution, Daisy was saying the principles of the Constitution are a result of judicial decisions. That's the third concept of the rule of law. In the political and legal theory, it has come to be read in a narrow sense, that the government shall be ruled by the law and be subject to it. The idea of the rule of law in this sense is often expressed by the phrase sovereign by law and not by men. That's just a little bit about the rule of law. Now, we have a look at the function of the judiciary, the judge, or the court. The duty of the court, and its only duty, is to expound the language of the Act in accordance with the settled rules of construction. Lord Macnaghten in Vecher and Son and London Society of Compositors, quoted by Raja Zan Shah in Lo Kui Chul. In Chow Cham Guan against the AG of Malaysia, the learned judge said, the law may be harsh, but the role of the court is only to administer the law as it stands. Basically, the role of the judiciary is to interpret the law as it stands. Can I have some? Water. Yeah, water. Thank you. The water is more important than. That should be the function of the judge, the court, or the judiciary. I humbly submit that the development, as I can see, and as indirectly mentioned by Professor Osgar, makes me wonder whether there will be a clash between the judiciary and the parliament later on. It's for time to see. Lately, judges tend to embark on what we call judicial activism. Simply means judges make the judgment based on their personal opinion. That's all. I don't have to quote so many writers here. Some refers to judicial ruling based on personal opinion rather than on existing law. And under this judicial activism, judges allow their personal views about public policy to guide the decisions. Now, this includes overturning laws as unconstitutional, overturning judicial precedent, doctrine of stare decisis, ruling against the preferred interpretation of the Constitution. This is a ramification of the introduction of basic structure into our Constitution. Supporters of judicial activism say that it is a legitimate form of judicial review. And so, as they say, interpretation of law must change with changing times. But critics of judicial activism charge that It usurps the power of elected government, damaging democracy and rule of law. Activist judges discharge their functions exceeding what the Constitution provides. That's basically what it's all about, judicial activism. It's up to the judiciary to determine their, not to say their own future, but the way they run the judiciary. But then we have to remember, in Malaysia we have the doctrine of separation of powers, where the judges have to interpret the law as it stands, and making changes to amendment, making changes to the law is the duty of the parliament, whereas the executive carries on administering the country. Now, this basic structure of the Constitution, it originated from the Indian Supreme Court in the case of, as mentioned by Professor Dr. C. Ashkar just now, Kesavananda Bharati against State of Kerala, decided in 1973. Now, the court held that Article 368, that is the enabling article of the Indian Constitution, to amend the Indian Constitution, that the article does not enable Parliament to alter the basic structure or framework of the Constitution. The basic structure includes the system of government of republic and presidency in India, basic rights, freedom of the fundamental liberties and whatnot. Those are considered to be the basic structure of the Constitution. Now, the judgment also introduced certain provisions of the Indian Constitution form the basic structure of the Constitution. And based on this decision, the court will decide which provisions of the Constitution form the basic structure on a case-by-case basis. The court has the power to determine what is the basic structure, and this basic structure cannot be amended at the whim and fancies of the Parliament. Now, it means that the amending power of Parliament is limited. But then we have to look at the background. When Kesavananda Bharati was delivered, it was during the so-called government of Indira Gandhi, who were very strict, very harsh, and as a result, this case came up and the court ruled as it ruled by introducing the concept of basic structure of the Constitution. Now, in Malaysia, the power to amend the Constitution is vested in Parliament. That's very clear. And nowhere does the Constitution say that certain articles form the basic structure of the Malaysian Constitution and cannot be amended. Nowhere. Nowhere does it say that the court may decide on a case-to-case basis which articles form part of basic structure of the Constitution or not, and therefore may or may not be amended. There is no such thing. There is no such thing in the Malaysian Constitution as a basic structure of the Constitution. I misplaced some of the notes. Never mind, let's be off the cuff. Article 159 gives power to Parliament to amend the Constitution. There are 4 ways of amending the Constitution that was mentioned in Law Kuichun. Number 1, Clause 3. That is, the Constitution can be amended by 2/3 majority. And then Clause 4, by just simple majority. And then Clause 5, by 2/3 majority of Parliament plus the consent of the Conference of Rulers. Article 161(e)(2) provides that the Constitution can be amended by 2/3 majority plus the consent of the governors of the East Malaysian state, namely Sabah and Sarawak. Those are the 4 ways that we can amend the Constitution. And interestingly, Parliament can amend the Constitution although the amendment is inconsistent with the Constitution. That is very clear. Now, if the supreme policing role of Judiciary is to be applied strictly, it means that the Judiciary is usurping the power of Parliament. Now we must remember, Parliament is made up of presently 222 members, elected by the people, but not the Judiciary. The Judiciary can have a quorum of 7 and then make a ruling against Parliament according to their interpretation. I don't think that is in line with the concept of doctrine of separation of powers. Now the only way out is for Parliament to outdo, nullify whatever the court decision is. This has happened so many times. If the Judiciary makes judgment which is not incompatible with what Parliament is having in mind, Parliament will normally amend the law or amend the Constitution. But the problem is that now, is that the ruling party has not had the 2/3 majority since during election 2008, 2013, and this time around we just don't know. So the only way for Parliament to make sure that the law stands as it is, and to avoid the Judiciary encroaching into their realm, is to put forward constitutional amendment. But one thing about the Parliament and the Executive, the people, the human beings in the organization sometimes are not sensitive. I take, for example, the case of Bonsam Punyanin against Arona. Arona Properties and Bonsam Punyanin. 2001. The Federal Court, with due respect, wrongly decided the case. It said that the concept of indivisibility of title is to be immediate. I'm so sorry. Somewhere along the
Assalamualaikum. Assalamualaikum warahmatullahi wabarakatuh. You know, I have undergone 6 surgeries, but all are from the neck downwards. So inshallah, anything about the neck is still original. Subject to wear and tear. Yang amat berhormat Datuk Seri Diraja Haji Adnan bin Haji Yaakob Menteri Besar Bahang, Professors, Datuk-datuk, participants, ladies and gentlemen. When Dr. Azmi told me about this symposium, I said to him that if the organizers were willing to hire an ambulance to take me there, I would be prepared to go. As it turned out to be, IIUM has its own ambulance, so I'm here.